In 2025, the unthinkable is becoming reality. Thousands of naturalized Americans and green card holders are discovering that their citizenship or residency status is no longer permanent. A single forgotten detail, an old mistake, or a misstep in your paperwork can now strip you of everything, and deportation may follow swiftly. Under President Trump's 2025 immigration policies, denaturalization has surged to the top of the Department of Justice's DOJ priorities. A formal DOJ memorandum now directs federal prosecutors to target immigrants who allegedly lied, concealed information, or used fraudulent documents when obtaining their green card or naturalization. Civil denaturalization is a powerful tool. You don't need to be charged with a crime, let alone convicted. All it takes is a civil lawsuit in federal court, where a judge can strip you of citizenship without a jury trial. What is denaturalization? Denaturalization is the process of revoking U.S. citizenship after it has already been granted. Unlike deportation for a criminal offense, this is a civil action. The DOJ only needs to show that you gained immigration benefits by willfully misrepresenting or hiding facts. If successful, the government can cancel your citizenship and you instantly become deportable. Why is this happening now? This aggressive approach ties directly into Trump's wider 2025 immigration crackdown. USCIS has been collaborating with the DOJ to re-examine old applications, some dating back decades. Immigration officers are comparing files for contradictions, reviewing records from other federal agencies, and sharing flagged cases with DOJ lawyers. Officials claim this effort is to restore integrity to the immigration system, but critics argue it targets immigrants indiscriminately, even those who made innocent mistakes. Triggers that can make you a target. The DOJ isn't pursuing everyone. They're focusing on individuals with certain risk factors, such as obtaining a green card through marriage fraud or a fake relationship, lying about marital status or hiding prior marriages abroad, concealing past crimes or arrests, even if they were never prosecuted, using fake job offers, sponsors, or documents in the immigration process, working with corrupt attorneys or agents who submitted fraudulent paperwork, committing fraud against U.S. government programs like Medicaid or welfare, being linked, however loosely, to national security concerns. Examples of real denaturalization cases in 2025. These cases are already playing out in federal courts. A green card holder who married a U.S. citizen, never lived together, divorced quickly, and later naturalized, now facing denaturalization for marriage fraud. A naturalized citizen who failed to disclose a past marriage abroad, discovered years later. Individuals who lied on the N400 citizenship form about criminal history, even for minor fraud. Immigrants who secured employment-based green cards using falsified letters from employers who didn't exist. Applicants who unknowingly hired crooked immigration consultants only to have their applications flagged for misrepresentation. The dangerous N400 question. One question on the citizenship application: have you ever committed, assisted, or tried to commit a crime for which you were not arrested? Has become a central weapon in denaturalization cases. Many immigrants answered no, without realizing past mistakes could count. If the government finds evidence contradicting your answer, they can accuse you of fraud, reopen your case, and file for denaturalization. What happens after losing citizenship? Denaturalization is final. Once a federal judge revokes your citizenship, you don't revert to a green card holder. You immediately lose all lawful status and become subject to removal. The government can start deportation proceedings right away. There's no appeal through USCIS, only a brief window to contest the ruling in immigration court. And since denaturalization is a civil case, the government doesn't need to meet the high standard of proof required in criminal trials, making it far easier for them to win. How denaturalization fits into the broader crackdown. Trump's 2025 immigration agenda doesn't stop at denaturalization. USCIS is denying green card renewals and N400 applications at record rates. Longtime permanent residents are being questioned and sometimes detained at reentry ports. USCIS and IC are reviewing past approvals for marriage and employment-based green cards, reopening cases where they suspect fraud, even if years have passed. What you must do now. If you're a green card holder or naturalized citizen, don't assume you're safe. Carefully review your old applications. Ask yourself, did you omit any arrests or legal issues? Was your marriage, job offer, or sponsor completely legitimate? Were you coached to give misleading answers by a lawyer or a fixer? Could something in your past raise red flags today? If there's anything questionable, do not file paperwork or travel abroad without first consulting a qualified immigration attorney. Even a routine green card renewal or naturalization application can trigger an investigation under these new priorities. A new layer of risk in 2025. In a chilling sign of the times, immigrants across the U.S., some here for decades, are afraid to leave the country, fearing denial of re-entry. Others are quietly withdrawing citizenship applications, terrified of having old mistakes exposed. Under these unprecedented enforcement measures, your past can return without warning, and the consequences are life-altering. Final thoughts. The Trump administration's 2025 denaturalization push has created an environment where green card holders and naturalized citizens can no longer feel secure. The DOJ's use of civil courts to strip citizenship is a sharp departure from past practice. If you have any doubt about your immigration history, seek legal help immediately. One mistake, no matter how small or old, can now cost you everything you've worked for in America. Please subscribe for more updates, and thanks for watching.